About Franchise Law 101. So, or in other words, what you should know before investing in a franchise. So the first question is, who actually regulates franchising in the United States? Franchising is regulated by the U.S. Federal Trade Commission, the FTC, and also by various state agencies. For example, California, which was the first state in the country to have a franchise law. New York and Virginia, Maryland, and Indiana and Illinois, and others. Pennsylvania, where I'm based out of, currently does not have a franchise law, but it does have a House bill that's been pending that may regulate the franchisee-franchisor relationship down the road. I'll keep you posted on that. What is a franchise? Under federal law, the franchises are regulated under the Federal Trade Commission's franchise rule. And under that rule, there are three elements to be a franchise. It's a three-pronged test. The first is that there must be a trademark that you are offering to another party to operate a business under. So it's your trademark that you have registered with the U.S. Patent and Trademark Office, which you are then licensing someone else to have the right to use. That's the first part of the test. Without a trademark, under federal law, you are not a franchise. Under some states, you might be, but under federal law, you would not be. Federal law, you might be a business opportunity, though, and you do have regulations that govern that. Second element of a franchise under the FTC rule is that there must be significant amount of control that a franchisor exercises over that franchisee or licensee. Some of the evidences of that significant control or assistance would be things such as requirements for site design or appearance, designated hours where you tell your licensee or franchisee what hours they must be open for operation, specific production techniques if there is production involved, requirements for accounting practices, requirements for using your point of sale system, required participation in promotional campaigns, required training programs or procedures that you must follow, providing an operations manual to them with specific requirements as well. That's all evidence of control, but it's a very vague area. As far as the payment, that's the third element or prong of the test. There is a required payment, and that is a very minimal threshold to meet. And that payment is that the franchisee is required to pay to the franchisor or the licensee to the licensor or their affiliate at least $500 in the first 6 months of being open for business, of the relationship, basically. And that $500 can be for all kinds of things. It can be for training, it can be for product, it can be for services that the franchisor charges for. It's a very open-ended definition, so that one's very easy to meet. So if those three elements are there, trademark, which you are licensing to another party, you are exercising control over that party, and you charge $500 or greater in the first 6 months of the relationship, then it is going to be called a franchise under the FTC franchise rule, regardless of what you call it in the contract. So why should you hire a franchise attorney to evaluate the documents? Why not hire your brother or your sister or your friend or whomever who is a general attorney or a personal injury attorney or estate planning attorney or any other bankruptcy attorney? Well, the reason is that this is a very specific area of the law. It's a very niche practice, and it's a highly regulated area of the law, and those types of attorneys are not familiar with what's typical, what's not typical, and the kinds of things that should be of concern to you and the kinds of things that are not so of concern. Next question I get is, well, isn't it all written in stone? Is this agreement really negotiable? And if it's not, why do I need an attorney to evaluate the documents? Well, the reality is that many are not negotiable documents when you are presented as a franchisee with a franchise agreement. Nonetheless, even if it's written in stone and it's not negotiable, it's very important that you have a clear understanding of what your obligations are to the franchisor and what your expectations of that franchisor should be. It's very important to work with someone who has the knowledge and experience to be able to advise you properly. This is a very large investment. Typically, it's a large financial investment, not just the upfront fees that you're going to be paying to the franchisor or their affiliate, but also the cost to actually get the business up and running. If it's brick and mortar, the build out, it could be tens of thousands, hundreds of thousands of dollars. But also, besides the monetary investment, is the investment of your time and your energy, which is also substantial. So it could be a very costly mistake, which is very hard to undo if once you've signed that franchise agreement. And lastly, you want to have a responsive, experienced attorney, and one that charges a reasonable flat fee. And I'll talk about it later, but our flat fee hasn't changed in over 9 years. So the document you're going to be presented with as a prospective franchisee is called a franchise disclosure document, or known as an FDD. And what does that consist of? Well, it's a huge document, typically hundreds of pages. And the front section is 23 items, and they're literally called items 1, item 2, item 3, and so on. 23 just being typically the receipt. And those 23 federally required items are the disclosure items that the federal law says you must have, and the disclosure that the franchisor must be making to you. They are required to be written in plain English, and I strongly recommend that you read through those items. Just to give you a little sampling, item 1 is the background about the company, its parents, predecessors, affiliated businesses, competition in the industry, regulations in the industry. Item 2 is information about the people that you're going to be working with this franchise, and who are they, and what is their background, and what does their resume look like? Are they fly-by-night people? Have they been with this business for a while? Items 3 and 4 are the litigation and bankruptcy disclosures, and that can be very telling too. Obviously, if there's a lot of bankruptcies, is this a business you really want to be involved with? As far as item 3 in the litigation, if there's a lot of litigation by franchisees against the franchisor, or vice versa, it often shows a lot of unrest in the system. And again, is that a system you want to be involved with? Items 5, 6, and 7 are the financial disclosures. And those are very important for you to be very familiar with. You should even read the footnotes to those items. Item 5 is the fees that you're going to pay the franchisor or their affiliate up front. Item 6 is the fees that you'll pay the franchisor or their affiliate on an ongoing basis. And item 7 is the chart that says this is what it's likely to cost you to get this business open, and typically what it'll run even in the first few months. In those 3, I would strongly recommend that you read even the footnotes to them, as I mentioned, because there's a lot of valuable information in the footnotes. I'm going to mention one other item that's not on the slide in front of you, and that's item 19, which is the financial performance representation. And I would definitely read through that very carefully. If you plan on relying on it, read through the footnotes to it as well. And I'm pretty sure you're going to see that the attorney who drafted that probably told you not to rely on it because your experience is going to be different. So I just want to point that out. That's my feeling as well. In that FDD will also be all of the contracts that you will be asked to sign as a franchisee. Most importantly is the franchise agreement, which is your contract with the franchisor that defines your relationship under the franchise. That franchise agreement will have everything in it that is important for you to understand, and that's another reason why having an experienced franchise attorney to advise you on what's in there so that you understand going forward what your obligations are. Because these contracts are typically at least 10 years in duration, and they're pretty one-sided often, and certainly there are very rarely opportunities for you to be able to terminate it. Other contracts also will be in the FDD, such as if you are investing in an area development or multi-unit, there might be an area development agreement or multi-unit agreement. There's non-compete agreements typically, and personal guarantees that you're going to have to sign. All important documents for you to understand. In addition, there are also going to be, if this franchise isn't just a startup, a brand new franchise, but rather one that's been around for a few years, there will be audited financial statements of the franchisor. I always recommend that you have those evaluated by a good business accountant. preferably even someone with franchise background, but certainly a business accountant that's comfortable reviewing audited financials. And you want them to look at those financial statements in light of the system that is in place by that franchise and what is the growth that they're expecting. And item 20 of that FDD will explain what kind of growth they're anticipating, and is this franchisor financially strong enough to support the system today and the growth they're expecting, because you don't want to be involved with a franchisor that goes into bankruptcy. Most franchisees do not survive that. What types of revisions can be made to the documents? Well, first question is, what type of matters are negotiable? And typically we find there are a handful of kinds of things that might be negotiable. Territory rights is often negotiable. Maybe the notices on default, or giving you, maybe instead of no notice, giving you 5 days notice or 10 days notice of a default. What are the franchisor's remedies on default? Sometimes we're able to soften those a little bit. What are your rights on renewal? And what are the requirements for remodeling the store? Are you required to remodel every 3 years or 5 years? Sometimes we're able to change that. And what about equipment updates? And other non-monetary rights are typically the ones that are negotiable. Typically, things that aren't negotiable will be any monetary obligations, such as fees that you're required to pay, funds that you might have, advertising funds and other funds that you might be required to pay into, and so forth. The term is also something that's typically not negotiable. And which franchisors typically negotiate? Well, the newer systems, the hungry ones that are trying to get as many franchisees into their system and building that up, those are the ones that are usually more agreeable to negotiating. Promissory notes, personal guarantees, these should be reviewed. They often are negotiable, and they definitely should be reviewed by an attorney that can help you with that. So what are our services and our flat fees? Well, we always start by checking the trademark and making sure it is registered with the U.S. Patent and Trademark Office. We do that as our first step. We check the records of the state in which the territory is going to be located. We want to make sure that any name of the business that you're going to be using, that brand, isn't being used by a local business that might have used it before the trademark was registered, because if they had, that local business actually has priority rights to that name in that marketing area. Under trademark law is based on use and not on registration, and so we check those state records and we ask you to check locally to make sure that there isn't another business operating under the same or similar name. We review items 1 through 4 of the FDD, which includes investigating any litigation that might be disclosed in item 3, because that gives us a great background about the company and, again, information that I think is very important for you. We don't review items 5 through 23 because everything that we need to know that's in those items is actually part of your franchise agreement, and that, again, is the contract with the franchisor. That we go through very, very thoroughly from cover to cover. We then go over everything with you as our client / prospective franchisee to make sure, again, that you have a clear understanding of what you're entering into and what your obligations are to the franchisor, what your expectations of the franchisor should be. That's typically a phone call that's 1 to 3 hours in duration. We negotiate the revisions to the franchise agreement on your behalf with the franchisor. We will also draft an addendum to the franchise agreement that will incorporate those revisions, and we charge a flat fee for those services, and our flat fee hasn't changed in 9 years. We also can set up your entity for you as a corporation or a limited liability company in the state in which your territory is going to be located. We do that for a flat fee as well. We can review, revise, and negotiate your lease if it's a brick and mortar business. And we do a tremendous amount of commercial lease reviews and negotiations. I'll have another video of commercial lease negotiation on the website as well. And we, down the road, when you're ready to sell your business, we can also help you with that. Or if you're acquiring a business, a franchise business, we can help you with that as well. So we're here to help you all the way through with your business, and anything that we can't specifically help you with for whatever reason, we certainly can help you find a good lawyer that locally that can help you. So we're here to help you any way that we can. That's my phone number and extension, my name, phone number, and extension, and we would love that opportunity. So here's my full contact information. We are nationwide franchise attorneys, and we would love the opportunity to work with you and help you understand what it is that you're investing in before you make that commitment. We hope that you've enjoyed this presentation. And if you have, please give us a call and give me a call, and I would love to talk to you. So have a great day, and look forward to hearing from you.